Welcome, everyone, to the International Institute of Genealogical Studies, found at genealogicalstudies.com. I'm your host for this presentation. My name is Drew von Hasselback. I am a mentoring professor in Canadian Studies at the International Institute. Welcome, everyone. I have put together something to introduce you to wills. So in your Canadian Studies courses, you have two required courses. You get an introductory course to wills in estate records, and then you get an advanced course. I just recently finished putting together some fresh course materials for those courses. So I don't know if you've already taken those courses, but if you haven't, you might have a shot at being the first people who get to see my new materials. But even if you have, here is a little taste. I am going to do a little presentation now. I'm calling it Signed, Sealed, and Deceased, the Anatomy of a Will. And what I hope to do here is take apart a will, show you how it's put together, and you can learn how to extract that information in your genealogical research. So, Signed, Sealed, Deceased, the Anatomy of a Will. Understanding the language and formats of wills for genealogical research. Just brief introduction as to who I am. Um, I've been doing genealogical research for about 30 years. Um, I am fairly recently a graduate of the International Institute, so I know what you're going through if you're still doing your courses. I only got my PLCDS in October 2022. So when I was taking my courses, though, the Wills and Estate Records was probably one of my favorites, and I'll tell you why. I just love these documents. When it comes to proving a lineage, they're almost perfect for you because you'll have the testator naming family members, perhaps children, perhaps even grandchildren, nieces, nephews, grandnieces, grandnephews. And this can be incredibly powerful if you're trying to do an argument that creates a lineage in the family. So, quick disclaimer though. This information is provided for general information and genealogical research purposes only. It's not intended as legal advice. I am I am going to talk a little bit about some legal history, but I'm not here to teach you how to do your will. Right. Okay, so let's review some of the objectives that we have for tonight, for this class. Well, I'm going to introduce you to the historical requirements that go into the drafting of wills. I'm going to take you through the basic structure of an actual will. And then we're going to read this will together. You'll see it, it'll be on your screen. You'll see the actual wording, and you'll, I hope, see how it can actually help you in your genealogical research. So, pretty simple stuff, I hope. So, what's a will? Well, a will is a legal document. It outlines what to do with property after an individual has passed away. One thing about wills in common law, that's the law that we use in Canada, in English-speaking Canada, the United States, Australia, New Zealand, the whole English-speaking world, the rules are pretty much the same. Now, you will get unique legislative requirements in particular jurisdictions, but they're all premised on the same concepts, the concepts that I'm going to be talking about today. So if you're not doing Canadian courses and you're just here to check out the presentation, but you are doing research in another jurisdiction like Australia, uh, you should find this useful. All right, so let's address some of this legal history. There's actually there's two laws that underpin all of this, and they're pretty old. So we're going to go back to 1677 with the Statute of Frauds. I'm going to tell you a little bit about that one. And then I'm going to tell you about a law that's almost 200 years old, the Wills Act from England, 1837. Now let's take a look at these. And it's not going to be as daunting as that old-fashioned writing might make it look. So the Statute of Frauds. It's a very important thing for you to understand, not just for wills and estates research, but if you're doing land records research. That's actually the real reason I wanted to show you this law. It says that all land transactions must be in writing and signed by the person giving the land away. Now, what does that mean? That means that as a researcher, if you have ancestors that transacted land, there will be written documents that attest to this fact. And it's the same thing if you're leaving land in a will. It says right there, bequests of any lands. Bequest, that's a legal word for leaving something in an estate. Um, they have to be in writing, shall be in writing. That's the actual language in this very old law, and signed by the party. Okay, so this other law that I talked about, the Wills Act 1837, you're going to see how this is going to benefit you. First off, again, it shall be in writing. Now, why am I showing you a law that says exactly like the last one did? The last one just talked about land. The Wills Act talked about everything. So every kind of property that you can imagine. If it's covered in a will, the will has to be in writing. The will has to be signed at the foot or the end by the testator. So you can't sign at the top, you can't sign at the side, you got to sign it at the bottom. Why would they do that? Well, if you draft a will, you have all the clauses in there, and maybe even you have some space between where the writing ends and where the person signs. You might, if you look at wills, you'll see there'll be like this curly line where they sort of scratch out to indicate that that space is supposed to be there and there's not supposed to be any writing there. If you sign your name at the bottom, that indicates, yeah, you've read everything all the way down to that point, so nobody snuck something in after the fact. Now, this is important. Not only does the testator have to sign the will, it's got to be signed in the presence of two or more witnesses. So those witnesses, they can't, the testator can't sign the will and go across the street to the neighbor and say, "Hey, I just signed my will. Can you say that you witnessed it?" No, the witnesses have to be there and watch it happen. Okay, so those are all the formalities. That's what we call them, the formalities. And pretty simple. I said, will's got to be in writing, will's got to be signed at the bottom, and there's got to be two witnesses that see the testator sign the will. So that's the whole of the law that you need to understand for wills. And pretty straightforward, I hope. Um, Now let's talk about the outline of a will. This is a very basic outline. Wills are supposed to be very simple documents. Why? Because we want people to draft wills. We want people to put their estates in wills so that the heirs aren't left, trying to figure out what to do with all this stuff or fight over it or fight over the property, whatnot. So here's the basic outline. The beginning. Now you've probably seen this. You probably had, seen a will where it says, "I, Drew von Hasselbach, being of sound mind," and so on. Uh, there's different variations on what people put at the top. If you see some really old wills, they'll say, "In the name of God, Amen." And they start with like a religious uh, beginning, and they'll talk about, "I'm returning my soul to the God who gave it," sort of thing. Well, in law, they just call that the beginning. Straightforward. If you look at the bottom here, or close to the bottom, you'll see where I have a signature, attestation. Now, as I said, the signature's got to be at the bottom. And the attestation clause, that's the thing where the witnesses say, "Yes, we saw the testator sign the will." Now, why did I jump to the bottom? Because these things I have in the middle here, revocation, funeral, burial instructions, specific bequests, residue, appointment of executors and trustees, they don't have to be in that order. I've put them in this order because of the will that you're going to look at. It follows this order, but those can appear in any order. It's just as long as they show up somewhere in the will. Um, that's all that's, I wouldn't say required, but that's all that you'll typically see. Um, Before we got things going here, we were having just a little conversation. We're talking about like modern wills versus old wills. Like one key difference, I think, between a modern will and an older will is a modern will, you'll tend to see the appointment of the executors near the top. And in a lot of the older wills I see, the appointment of the executor is at the bottom. Why? I don't know. It's just the way things work. So let's look at a will. This is the will of Annalene Patterson. She passed away in 1923. And what do I have here on this screen? I have a citation. There's one thing you learn in this course, in all your International Institute of Genealogical Studies courses, do citations. Now, is there a right way, a wrong way? Not necessarily, so long as you just provide enough information to tell people where you found the information. You got to tell people why you know what you know. And in this particular case, I found this document and I left a citation here that I think explains how you could go find it on familysearch.org. Um, what do we see in this document? And don't worry, you're going to see this closer, up close. You see that the will was signed on the 28th of June, 1922. That you always, as a genealogist, you always want to pay attention to when that will was signed. Because let's say they mentioned some family members who are alive in the will, uh, you know that they're alive as of that date. Well, in a lot of cases, somebody could sign a will and they might not pass away for 25 years. So a lot can happen between the time when the will was originally signed and the will was taken to court for what they call probate, where it gets examined by the court, approved, and then the estate can be distributed. So a lot can happen between when a will is originally drafted and when it is executed. So that's why you want to pay attention to when that person signed the will. Now, what actually happened here? Well, since we're looking at a will, Annalene must have died. And I looked it up, and sure enough, she did die on the 23rd of November, 1923. I found her death certificate on Family Search, so I left a note there with a citation for anybody who wants to know. Now, quick note. When you do your research, do you want to look at a derivative document or do you want to look at the original document? You know the answer. You always want to look at the original document. I have to tell you something. Here, you're looking at a derivative document. It's a typed transcription. The original will also lives in the estate file where I found this. Just for tonight's, or just our purposes of this presentation, I found it. I thought it would be more useful for people and easier to deal with the typed version, but we will take a quick look at part of the original. Um, so let's zero in. Remember, I talked about these elements. There's the beginning. We'll zoom in a second, but just so you can see it all laid out here. There's the beginning. We have a revocation clause, there's a funeral clause, and all these other clauses I mentioned are right there. They're all lined up. You can see it all fits on one page. And actually, let's take a look. So here's how it starts. She says, "This is the last will and testament of me, Annalene Patterson of Aylesford in the County of Kings and Province of Nova Scotia, made this 28th day of June in the year of our Lord, 1922." So simple beginning. She says who she is, where she's from. Where she's from is really important because that will nail down the jurisdiction where the will have to get probated if she dies in that jurisdiction. And of course, the date, right? We always want to know when people sign their wills. So that takes care of the beginning. Very simple. You don't even have to you don't need a law degree to read what she's getting to there. Now we come to a revocation clause. What's the magic word in a revocation clause? I revoke. And if you think it through, you'll see that this is a perfectly logical thing to put in a will. If you happen to have other wills that you've signed in the past, you want to make sure you wipe those out so that your heirs aren't left holding two, three, four, five wills and arguing over which one is the valid one. So if you say, I revoke all the former ones, it wipes them out. You've got a fresh start, you've got a fresh document, and it just makes everything easier for everybody. One thing about the wording that you'll see here, and so um, when you do your transcription course, you're going to learn how to abstract and extract. And one of the things that we're going to tell you is the great thing about abstracting and extracting is you can drop the boilerplate. What do we mean by that? Well, there's some language that just pops up in documents all the time. Like in her case, when you see her actual will, it was what they call a pre-printed document. She had it like it came pre-formed, and then she wrote some bits in handwriting on top of it. So a lot of the language here was actually just written right into the page. It wasn't written by her lawyer for her. It was just already there. So it's boilerplate in the sense that it doesn't really tell us a lot that we need to know as genealogists. That's why in your transcription courses we'll say, hey, you don't have to worry about transcribing the boilerplate. I mention that because I know it's very confusing and it's very hard when you're starting to deal with these documents the first time. You don't know what boilerplate is. I mean, all looks kind of important. It all looks legal and flowery. So here's an example of just standard legal boilerplate. All you really need to pay attention to are those magic words, I revoke. That takes care of that. And we move on to the next thing. Funeral and burial instructions. And also in here, we talk about paying debts. So I direct, standard legal language that just means, hey, get the, Mr. or Miss Executor, whoever it is, get this done. I direct. Pay for my funeral. So you don't always see these in wills. A lot of the times, testators will just say, "Hey, take care of my debts," and they won't get into specific instructions for funeral expenses. But it's pretty standard to see something in there. Pay for my funeral, buy me a tombstone, bury me in the specific location, scatter my ashes in the Atlantic, whatever it might be. You will see that and in wills, and you'll see specific instructions from time to time. Then you'll get to the specific bequests and legacies. This is what you really think of when you think of a will. This is where the person says, so and so gets this, so and so gets that. Now, first magic phrase that you're seeing in here, I give, devise, and bequeath. You've probably noticed if you've read some legal documents already that lawyers like to repeat verbs. I give and bequeath. Uh, I I give and devise. I will and bequeath. Why do they do that? Well, historically, each of these verbs, give, devise, bequeath, referred to giving a specific kind of property. Devise was the word that you used when you were talking about giving somebody land. Bequeath was the word you used when you talked about giving somebody property that wasn't land. Um, a little confusing. The tying those verbs with the specific action sort of fell out of use. So what do lawyers do? They just say all three at the same time, takes care of any situation, makes life a lot easier. I give, devise, and bequeath, and then we talk about her property, real and personal estate. Very important to understand anywhere in the common law world, there are two kinds of property. There's land and there's everything else. So land is known as real property. Real doesn't mean like in reality. Real is derived from the old word for royal, because land is something that was conveyed by the sovereign and it was conveyed in the states. So real property referred to property that um, was land that was authorized by the sovereign to go to whoever had the right to live there. Okay, so that's where real comes from. That's realty. Real property just means land. Personal estate, fancy way to say everything else, every other kind of property that's not land. Now, Annalene Patterson leaves her first bequest. So it's a sum of money, $650. And she's saying, take that money and put it somewhere where it generates interest to care for Togo, my cat. So Togo, my cat, was going to live the life of whatever was in fortunate circumstances, I suppose, because Togo was promised comfortable maintenance until his death. And actually, if you read on, after his death, she left some funeral instructions for Togo. He was to be placed in a clean box padded with papers and buried in my grave at my feet. So Togo plays a starring role in the will of Annalene Patterson. Now, after Togo is dead and gone, God rest his soul, the $650 that was set aside to generate interest to pay for his maintenance gets divided. And what does she do with that? Well, she says half of it's going to go to the Methodist Cemetery in Aylesford. Now, as a genealogist, you want to pay attention to that because what does that tell you? Methodist Cemetery in Aylesford? Probably where she's buried. The other half to the infant's home in Halifax, Nova Scotia. So she thinks of the cats and she thinks of the kids. Way to go there, Annalie. Now the specific bequests. Notice the cat got the money first. Now we bring in the family. There's a lot of them here, but this is the genealogical gold. Okay? So you see those specific amounts, $100, $100, $75, so on. And you see the names, but what do you see before the names? You see their relationship to her, right? So nephew, Percy Kirkpatrick, niece, Haley Davidson, grandniece, Blanche Welton, great niece, Ruth Welton. Um, and actually, remember how I said it's possible that, you sign your will and you may not die for 25 years. So who knows what happens with the people that you've promised the money to? She actually thought ahead. She said, hey, if either Blanche or Ruth pass away before the estate's settled, they the survivor of them gets the $150 instead of the half, the $75. Um, Paul Finney, he gets $50. Great niece Gladys Finney gets $50. I don't know why the Welton girls got $75 and the Finney kids only got 50, but you know, that's life in the city, I guess. Um, Somebody who's not a family member is mentioned, Nellie L. Parks. If you're doing fan club research, be pretty interesting to find out who Nellie was and why she was a friend or connection or somehow connected to Annaline. And she left money to the hospital. So great thing with specific bequests. You'll often see a relationship mentioned beside the person, and you can use that to reconstruct a family tree. You'll have to do other work, but it's a great foundational document for that type of research. Another clause that you'll see, really important, the residue clause. Exactly what it sounds like, the residue, the leftover. After the executor had gone through and paid out all the money that was supposed to be paid out, there may be property left over. So what do you do with that? And Annalene said, well, if you have residue, half's going to go to whoops, I'll go back to that. Half's going to go to the Canadian Bible Society, and half to the Nova Scotia Society for the Prevention of Cruelty. I'm assuming that means cruelty to animals, and of course, that should not come as a surprise to somebody who left money to her cat in her will. So that's Annaline. Now, appointment of an executor who's going to get this job. J.P. Raymond is named. I don't know if that's male or female, but it's just J.P. Raymond. His name's well, actually, no, he would be a he because he's described as an executor and not an executrix. J.P. Raymond is the executor. So um, now we come to the signature and attestation. As I had told you, you're looking at a typed transcription of the original. We should always, or sorry, yeah, typed transcription of the original. So this is technically a derivative document, but if the original is available, we should look at it. And there it is. You can see it. You can see Annaline's signature right there. You can see the signature of the two witnesses. And as I mentioned, you can see that there's some pre-printed wording there in witness whereof. That's what we talk about when we mean boilerplate. It was like printed right into the page. It wasn't written in a bespoke fashion for her own will. Um, you can see the quality of the handwriting there. That's also one of the reasons why I thought for the purposes of this presentation, it'd just be easier to deal with a typed document than the handwriting. But if we were doing this in person, we would definitely be doing our research off of the original handwritten document. Now, there's an eighth part of a will that you will see called a codicil. Now, we didn't see one in Annaline's will because she didn't have one. But you will see them in wills, and I'm about to show you one. A codicil, what is it? It's a legal amendment that's tacked on to the end of an existing will, and it has to be literally written right on one of the pages attached to the will. Um, it has to follow the same formalities. signature at the bottom, be in writing, have two witnesses view the testator, make that signature at the bottom. And I can show you an example. I'm going to show you an example from somebody named Timothy Eaton. I think we're all Canadians here tonight, and I wouldn't be surprised if you all quite remember who Timothy Eaton might have been. If you don't, that's the Timothy Eaton who founded the Eaton's department store. And he had a will that he signed on 19 November 1903. There it is right there. It's a surprisingly short document for a person who was that rich. He was really like he was one of the richest men in Canada when he passed away. Um, his I calculate that his net worth in today's money would be somewhere between 300 million and 500 million dollars, which doesn't sound like some of the richest people you know, but in the terms of the time, he in today's money, he would easily have been a billionaire several times over. Um, so yeah, it's a very short will for somebody who had that much property. But what happened here? He had his will, that's the 3 pages, but then there's this page here that is in handwriting. It's a codicil. It was signed uh, almost 2 years later. And let's take a look at what happened. Well, the handwriting might be a little difficult to read, but the operative words are down here. See, he had originally, in his original will, said that his wife would be entitled to the sum of $7,500 a year. But 2 years later, he decided she'd be entitled to $10,000. So he added this, he had this handwritten amendment added right into the will. He signed it. You can see his signature right there. He did sign it in the presence of two witnesses, so that made it official. And that's just an example of a codicil. You don't see a lot of those. They do arise, but I thought this would be a good one to share with you because it's a nice, notable example. And there you go. That's your tour through an actual will. So what did we actually learn from all of this? I shared with you the basic requirements of a will. If you follow those requirements, you have yourself what is called a formal will. There are such things as informal wills. And if you take the Wills and Estates course, you'll be introduced to some of those. But most of the time, the vast majority of the time, you're going to be dealing with formal wills, actual real wills. We learned some of the standard clauses and format that you'll see in a will. And I hopefully have documented that it's a great way to prove intergenerational connections. Now, I don't know if you have connections or questions, but if you do, there's Annalene Patterson's tombstone. I do not see Togo mentioned on the tombstone, although if Annalene's instructions were followed, Togo's down there somewhere. So hats off to Togo. And yeah, if anybody have any questions, you can either um, drop them in the chat, or um, I don't know if you want to speak. Just a reminder, we are being recorded, or we are recording this. Okay, there's somebody has a yes. Uh, Thank you. Are wills the only way to pass property on to family members? Laura, that is an excellent question, and the answer is no. If you don't do a will, you die intestate. That's the legal term. And every jurisdiction will have its own rules for this, but there's a simple or a general order that kicks in that automatically decides which family members should receive what portion of the estate. Now, you might think, oh, okay, well, if that's the case, then I don't need to worry about it. It's kind of a pain for the heirs that you leave behind. One of the things they have to do is they have to go to court and they have to apply for what is called letters of administration. So they have to go to court, tell a judge, um, sorry, Uncle Charlie didn't leave a will, but I'll step up and I'll be the administrator of the will and I'll take care of everything. And the judge will, if you're if he likes the cut of your jib, you get the job, and then you have to take care of making sure everybody gets paid out. The other thing that can happen too is if you have somebody who dies and there actually aren't family members around, whatever jurisdiction you're in will probably have a public guardian or trustee that will step in and take care of everything. Governments do not like to do that. I mean, they will do it because something has to happen, but the preference of all jurisdictions is that families take care of their own. So, yes, it is possible to pass will onto your family members after you die if you rely on the letters of administration process to kick in. The other thing, though, there's another answer to your question, which gets a little technical, but before you pass on, you can gift your property to family members. It's something called an inter vivos gift. Um, that is something that if you're contemplating doing, you probably want to talk to a lawyer before you do it to make sure that you don't run afoul of any property transfer taxes or anything like that. It's in Canada, there's some specific rules, but you want to be very careful about how you go about doing that. Is there a way to check for amendments on wills? Well, the documents that you're going to come across in your research, thank you for your question, Elaine, um, are documents that are filed in court, and they're filed in the probate court or the surrogate court. Those are the two names that you'll see associated with courts that handle wills and estates. And um, whether it's a letters of administration case or a probate case is what they call it when they're looking at the will. They say, yes, this will is valid, and on you go. You'll see right in there that the amendment or the codicil will have to be attached to the will. That's an amendment is not something that could happen outside of that legal process. If it does, it's not really going to be valid. It's not going to work. Good question. All right. I think what I'm going to do now um, is I am going to see if there's one more. Oh, I'm just going to remind you that I have a couple of handouts in the chat. So if you want more information, you can grab those. Um, just a reminder to everybody, thank you for attending this presentation. It's been brought to you by the International Institute of Genealogical Studies. You can find more information at genealogicalstudies.com. So thank you very much.